Hey everybody, it's Mark Pruitt with Strategic Estate Planning Services for another strategic money tip. I'm joined today with Lorne Book from a book law firm. Appreciate you being here with us, my friend.
Absolutely. Thanks for having me.
This is our third section as far as segment in regards to different topics. The first two were what we call Estate Planning 101 and 101 Part 2, as far as basic documents that you need to have in play. You did a great job on that. Now, one of the things that you and I talk about this one constantly, and this is how to pass information or how to pass assets. Let me back up, not information. How to pass assets down to your family and do it as seamlessly as possible. There's all kinds of different ways to pass assets down. And we see, I think you and I, between both of us, we have more war stories of how things have, what the intent was versus what really happened.
Very much so.
And so today's segment is really some things to do, some things to not do in regards to estate planning, of passing assets down. And so let's kind of do it this way. Let's start with beneficiaries. So why don't you tell us maybe in a brief setting, because beneficiaries versus what the will says. So I want this, I've got certain things on this beneficiaries, but we do have clients that tend to think, well, I have a will, and because I have a will, it's going to go down the way my will says. And that's not necessarily the case.
Yeah, that's exactly right. So what you're talking about is the concept of what we call probate assets. In other words, assets, the change in ownership of which is required to be governed by a probate court in the state, versus non-probate assets, assets that the individual owner of an account, like a life insurance policy, for example, can designate in advance who automatically becomes the legal owner of that benefit, of that money, of that account, without the need for a probate court to get involved. So we have probate assets and we have non-probate assets. And so when you talk about beneficiaries, what you're talking about is people designating in advance who the legal owners of those accounts or the recipients of those monies will be at death, with the intention that no court involvement has to take place. Right? Non-probate assets. Right. So the most common of those, life insurance policies, individual retirement accounts, 401ks, 403bs,
IRAs,
SEP IRAs, that's exactly right.
Annuities,
that's exactly right. Texas has some relatively new mechanisms, and we do not advise people go do this on their own, but there are some new mechanisms for designating a beneficiary for a house, for example.
Exactly.
A beneficiary for a car. So there are some planning techniques where you can take assets that would normally be considered probate assets. In other words, probate court has to exercise some scrutiny over this whole thing and move them out of that column and into the non-probate asset column.
And this could also be bank accounts even. There's ways to go in on bank accounts and designate beneficiaries.
That's right. That's right. So that's the non-probate side. And then you mentioned a last will and testament as a means of handling what we call probate assets. And so, if you just...
These are assets that don't have designated beneficiaries on them.
That's exactly right. Or maybe more succinctly, you're using the will to say who the intended beneficiaries are.
Correct.
But the will and the will alone is the document that says that, and therefore we've created a probate situation where the court has to examine the will, approve it, appoint your business manager. We call that person the executor, the person that you name in the document, and then follow that roadmap that you lay out in your will.
And I've seen it on bank accounts even. I've seen it on insurance policies. I've seen it on annuities, where all of that planning and thought process, whoever the agent was or whoever the person was dealing with the accounts, they put the estate of as the beneficiary. So tell them, what does that do? This is an item that could avoid probate. But because it says to the estate of, what did that just do?
So we were just talking about how you can use some planning techniques to take property out of the probate asset column and put it in the non-probate asset column. What you just described, designating the legal estate of a deceased individual as a beneficiary, And there are, by the way, sometimes strategic reasons for doing this.
Right.
But you're taking a otherwise non-probate asset
And making it probate.
out of that column and making it a probate asset. That's exactly
And
right.
most people don't even realize that's what they're doing. That's what I see. When you bring that to their attention, they're like, "Oh no, that's not what I want. That's not what we wanted to do."
That's exactly right. And let me go a step farther and say that the laws in our state and other states that undergird these two concepts are mutually exclusive of one another. And I'll tell you a quick war story real quick just while we're getting out. I had a client come to me. Client passed away. Client left a valid will and left all of his estate to a handful of different family members. He left a life insurance policy. He also left a significant amount of debt. And the life insurance policy was designed, based on his intent, was designed to pay off the debt. The beneficiary of that policy was an individual person.
Not an executor of the estate.
Not an executor of the estate, not in their capacity as executor of the estate, just an individual person. And in the mind of the person who made all of this plan, he thought that the named individual that he was naming as the beneficiary would take the money, do the right thing, and pay off the debt.
And they're not legally obligated to do that.
So there's nothing wrong with them doing the right thing, but you're exactly right. There's no legal obligation for a named beneficiary to do anything other than take that money. And I've seen a lot of broken hearts from family members, from friends who are very upset over these situations, and that's one of many that we've seen.
Right.
It's a planning error.
Well, and I see other ones such as, and we're bringing these errors up to you because hopefully just some common mistakes that we see that we don't want people to do, and we try to avoid these at all cost. You know, another one says, well, I've got 4 kids, and I want child number 1, they're the ones I trust that's going to do the right thing again. So I want my IRA to go to Johnny. And then Johnny's going to take that and distribute it to the other 3 kids. Well, Johnny, by you doing that, just inherited the entire tax bill on that IRA.
That's right.
And the other 3 kids did not inherit the tax bill whatsoever. So is Johnny legally obligated to distribute that down to the other 3? No, because it's technically his. I've seen houses that way, where they want a house to be on. They want this child to just sell the house and distribute it, so they basically make it to where that child's going to be in charge of it. Well, once it's done, it's kind of done. And one of the things I will tell you is once you are gone, as a mom and dad, you realize you are the buffer to your children. And once the buffers are gone, all the idiosyncrasies of your children and how they grew up, it surfaces. It's amazing how that does that. And it's the one where you say, well, you were always the bossy one. And all these things that come out, and they're coming out because you're no longer there, and they're going to keep peace with each other to keep you happy. When you're gone again, we want you making up the rest of the story of how these assets go down. We don't want your children making up the rest of the story of how these assets go down. Another one I think of, Lorne, is, and we've dealt with it recently, is to where the dad had a trust. He had stuff funded into the trust. He was into his 90s as far as age-wise. And all of a sudden he decided for ease that he was going to put, he had 2 children, a boy and a girl, and he was going to put his daughter's name on all the accounts to make it easier. Well, they already had power of attorneys. They already had all the documents in place. But by putting her name on the accounts, when he dies, tell him who owns the accounts.
Daughter, 100%.
The daughter. The daughter owns the accounts. So the will said one thing, but by placing her on the accounts as part owner, she's literally owner with her dad, she now owns the money. And so it can create, and we see this all the time, of intent is good, but reality is another thing. And so that becomes very, very important. Maybe talking about another one, I'd say, Lorne, is maybe talk about undivided property. So there's a farmhouse that's been in the family for years, and it passed from great-grandfather to grandfather to my dad to now to us. And I've got 4 brothers and sisters, and, it's 20 acres, and it's divided 4 ways, 5 acres apiece. The problem is it's undivided property. What problems can that cause?
Well, it can cause family turmoil for one, because what we very commonly see in those situations is not every beneficiary is on the same playing field in terms of affluence. So there very well may be the one who struggles really wants to sell that legacy farm, is what we would call it.
Right.
The others don't. And
Right.
that can create some friction, acrimony, and also cause a stalemate. We can see issues with inequality in the divided ownership, right? What if the pond's on one side of the property but not the other? Do I get all the pasture land and you get the barn dominium? Those can be issues, right? Especially if we're not selling. Mineral rights can become a real sticky wicket when we're dealing with that. So,
and I've even seen it to where mom or dad says, I'm going to put my kid's name on the asset ahead of time. And so mom and dad literally take their names off the asset. And they, unbeknownst to the kids, put all 4 of their names on that deed. That can cause issues tax-wise down the road too. And so what are some of the best advice that you can give people in regards to property? What do you recommend to people, whether it's a lake house, a home, farm property, raw land, stuff that's been passed down generations? What's your best recommendations for those?
sit down with a professional.
There you go.
Sit down with a professional and talk through it, because there are a number of different consequences. One that just popped in my mind while we were sitting here was bankruptcy protection or creditor protection. You want to, you got to evaluate your beneficiaries and know where they stand.
Right.
But you need to have these conversations, and these are the types of conversations that professional attorneys and estate planners are skilled, and we call it issue spotting, and in order to help clients navigate the unintended consequences of some of those things.
And it's real simple. How do you fix those things? Is, again, you don't operate on yourself. So what you do is, the best thing is to say, we're going to come in, we're going to ask you questions. So whether you're sitting with me, whether you're sitting with Lorne, either way, it's going to be the same thing. How do you want these assets to pass down at your death? Who else is involved in that? Is the property divided? Is it undivided? Do you want this bank account to go this way? Do you want this IRA to go this way? Another thing, per stirpes. So per stirpes basically is a Latin term for bloodline. So maybe explain to people how that being on an account or not being on an account can affect them in regards to passing assets down, whether there's a per stirpes on there or not.
Well, so being the named owner on account, and there are, if you've opened an account and done a signature card, there are a number of different boxes that you can check on how you want to designate the account. And you mentioned per stirpes, and you're exactly right. It's Latin for count by the head, basically. And the way that I explain just the concept, and without getting into the weeds of per stirpes, the concept of per stirpes, as I explain it to clients, is grandchild inheritance. In other words, in a very common planning scenario where a parent wants to leave money, let's say they have 2 children, and they want to leave it 50-50 equally to the children.
Right.
And then their children have grandchildren, for example. Well, per stirpes designations in the estate planning context would protect the grandchildren if their parent, who is a child of your client at this point, passed away first.
So if I'm a parent, I've got my 2 girls, and if they have children and one of my girls passes away, I want that daughter's share to go to my grandkids.
To her kids.
Right, to her kids.
Not
Right.
the other daughter.
Right.
And not the deceased child's spouse. That's another big area
Correct.
that clients want to avoid. They love the in-law spouse, but they're not trying to leave estate to them.
Because people don't think about it. What if that spouse gets remarried? Now you have an in-law that's not part of your bloodline, and there's a new person involved now that has now been remarried, and they're not a part of your family. That has nothing to do with your kids or your grandkids. So think of it like this. I want it to go to my wife and to my children and to my children's children, straight down the line of my family. And I don't want in-laws involved in that. And so there's planning that can be done to make that occur and to keep that line, the integrity of that line intact.
I made a note also, we were talking about income or affluent differences between beneficiaries. There are also life circumstances and judgment differences. Some beneficiaries may be very well adjusted, some may not. Some may struggle in very serious things, substance abuse, gambling, alcohol abuse. And we see clients that come in and their first blink may be to move away from that beneficiary, but there are planning techniques to protect beneficiaries from themselves.
Right. And that's exactly right. So there's all kinds of ways, as you can tell, in regards to how you pass assets down, whether it's POD, pay on death, TOD, transfer on death, whether it's beneficiary driven, whether it's driven through a will, whether it's driven through a trust, whether it's driven through a specific designation of how you want things to go down. The point is, we encourage you, don't try to do this stuff on your own, because this is where the messes start happening. You know, I tell people, I've seen families split over a snow globe. I've seen families upset because of who took the dog or what happened to the dog. I mean, it really has nothing to do with the snow globe. It's all the idiosyncrasies of the family. I mean, and those idiosyncrasies come out in full color once mom and dad have passed away. And so our job is to try to create as much peace as we possibly can within the family dynamic, but we have to have clarity, and you have to provide that clarity for your own family. And so keep those things in mind. Thank you so much for being here with us today in regards to the passing of money and how you can pass different assets down to your heirs. The point is, I think, Lorne, is there's way more ways to deal with this than just one way. There's multiple ways, and every family story and dynamic is a little bit different.
Absolutely. And I would make a parting comment just about how our overall planning needs change with respect to passing on assets as we get older and approach retirement age. When we're under, say, 60 or 65, we're in the accumulation stage where we're still working and we're still building that nest egg. After 60, 65, now we move to preserving what we've built because this is all that we have. Maybe we move to a fixed income. Planning strategies change also in terms of protecting after retirement what we've built in order to make sure those beneficiaries actually have something to inherit from us. And so those are other very important things, especially for our 60 to 65 and older client bases to consider as they move into this new phase of planning and what those goals look like.
And that lines up with exactly what I always tell clients is, it is the planning that you do at ages 20, 30, and 40 is not what you do at age 40, 50, and 60 or 20, 30, and 40 or 50, 60, or 70 or 80, 90, or 100. Your age, as you age, your planning is going to change. That makes a huge difference. And I'll encourage you in looking at this as well as updating documents. Making sure that, I talked to a client the other day and I said, when did you have these documents last looked at? And they said, well, we had it done in 2000. Well, that's a long time ago. And so when you're looking at that, the laws that were back in 2000, would you agree are not necessarily the same laws today?
Oh, definitely. Definitely different.
Changed.
Yeah. Oh, absolutely.
And some things have...
And several times at the federal and the state level.
And so that's why you have to, it's not a one and done. And think of it like this. You drive a car, you change the oil on the thing, and you do a tire rotation. And sometimes you have to get new tires because the old ones wear out. It's not any different with your legal documents. So there's lots of things. We buy a house, we have to do upkeep. We have to paint it. We have to change the air conditioner. There's things that we have to do for upkeep on documents, and it's not any different for documents. It's the exact same thing. So don't think of, well, it's one and done, because laws change, family dynamics change.
Everybody was younger 20 years ago.
Yes, they were, no doubt. Well, hopefully this has been helpful for you. I appreciate you being here. If you've got any questions, Lorne, why don't you tell them the best way to get a hold of you if they've got specific questions. For your-
Absolutely. So please visit us on the web at www.booklawfirm.com. So it's book like the one that you read, booklawfirm.com. Or you can always call our office at 214-305-6974. We're in Carrollton and would love to answer any questions that you have. Or if you need a relationship with a firm, we invite you to give us a call.
Also, if you want us to look at the beneficiaries, we'll do this as far as planning, because we are a planning firm. So we'll look at this and look at all your beneficiaries. We'll ask you, how do you want this to go down? And we'll ask it on each individual asset that you have. And so if you want to do just a review, you're welcome to call us as well at 1-800-381-8870. And Laura will find a time that works best for you. We'll sit down and we'll just review all your beneficiaries one at a time to make sure that there are no changes, or specifically that they're going to go down the way you want them to go down. Thank you guys for being here. This is another strategic money tip. God bless you. Have a great day and stay safe.
Thank you so much for joining us for today's Strategic Money Tip. If you have any questions about the material covered in today's video, or you'd like to speak with someone from our team, simply call our office at 1-800-381-8870. Also, while we have your attention, click the link below to watch our latest video. And to see more videos on tips just like this one, make sure to click the logo to subscribe to our channel. On behalf of the team at Strategic Estate Planning Services, thanks again for watching.